Okay, so now it's time for us to have a discussion, dialogue on this process, and coming up with a motion to move forward, basically, to allow us to have the clearest understanding of this process. Is there any questions from commissioners on what we're doing?
Yeah.
Commissioner Gonzalez?
Just to be clear, we're here today to figure out a course, a way for them to request the funds, right? That's all we're doing?
More or less. I mean, Rule 12 right now kind of talks about that, but it's somewhat unclear exactly. It could be kind of interpreted in a few different ways. So I think now is the time for us to make a list of concerns that we have. There's like a few of the things that I have is procurement, claims adjuster.
Right.
How do we identify the claims adjuster? What does a claims adjuster look like for something like this?
Sounds like Rule 12 is a good place to start.
Yeah, because that's really what the letters are requesting is how does somebody get or somebody or a group get access to the fund to do a health study.
Very good. Thanks.
Commissioner
I move to discuss Route 12.
I don't think we. No, I don't think at this point, I don't think we need a motion to discuss it. It's a little bit different because it's not like we're not in the middle of an application per se. This is more of administrative matters, so we can just kind of dialogue about that and then maybe move forward as a motion that's more specific. And for example, on the back of the report, there's a recommendation. Seen that part? So we're moving in that general direction, but I personally have a few more questions about that.
So can we go into discussion?
Yeah.
Okay. One thing that comes to my mind through this whole, as we're listening to testimony, and something that our planning director said, I would like to see an RFP, a request for proposal for this health study. And I don't read anything in Route 12. Well, first of all, Route 12 doesn't say anything about a health study, and I guess that's what we're going to discuss. We're discussing to have a health study, and if we do this health study, I want it to go out to in an RFP.
That's in line with the procurement. I think what we need is at some point here, so I don't know, make a list, maybe Darren, if you take note of some of the various things that we're bringing up, so such as the procurement process. I think we need a legal opinion on the procurement process, because it doesn't specifically say in Rule 12 that there is or is not, or that is or is not necessary. Commissioner Gonzalez, yes.
Okay, so if we're looking at 12.7, wouldn't that kind of be where a place you go? I mean, this isn't a claim, it's more of a request. I mean, is that something we could just reword? They could just follow that as a guideline?
It could be. I think that's a good.
Because if you look at 12.7 E1, I mean, they could, like Punapono, they could, on their behalf, they could make a claim for a request for funds for a study.
Mm-hmm.
If what I'm reading.
Yeah, 12-6A.
I'd say 12.7 B1.
Filing of claims. Each claim shall include the following information. One, name of claimant.
Yeah, and if you just went through all 8 of those steps, that would kind of seem like a way to.
Correct. I think that follows 12-6. Yeah. So, for example, 12-6A, claims for a community approved mitigation project shall address blah blah blah. Right.
Right.
I mean, so that's there. I mean, I think that's again we need to get a clear interpretation of that.
Is that a claim? I mean, are they finding a claim, or are they just making a request for funds? If so, can we use Rule 12 to do that?
Correct. is the case, it goes to a claims adjuster, which is the first thing when I read Rule 12 and in relation to the health study, I was like, how does a claims adjuster fit in to a health study? You know, this is different. So I think we need to define or request a definition of what a claims adjuster would look like for that. Because I always think insurance when I think of the claims adjuster, and this is different. Do you agree?
I agree, and again, if we look at 12.5, it kind of outlines how we would come up with the claims adjustment. By going through the requirements of the state procurement code.
And so, well, it defines that. What does the claims adjuster actually look like? What's the criteria for that? Are they a doctor? Are they specialized in mediation? Are they an attorney? And then I don't know if it's makes sense now, but potentially, you know, a way to identify mitigation measures. I mean, it's kind of right now just a way I feel it's open if somebody has a claim. Make a claim. Boom.
This would be the rule they follow if they had a claim.
Correct.
So I guess my question is asking for these funds for a study, is that a claim?
And I think that's where I want a legal opinion on it, because I don't know.
Is there a lawyer in the house?
Well, maybe here in a minute we can call for executive session to go into some of this in greater detail to get some legal advice.
Can the claim adjusters be like a hearings officer?
Well, yeah, when I first read it, I mean, I kind of interpreted, I went over to think that they could kind of be the same in a way. But again, I mean, I think it would be up to us to define what that claims adjuster would look like. And maybe that's something that we can ask in executive session. So, Madam Director, you know, on your recommendation here, for a director to assist in defining a clear process by which protocols, methodologies, guidelines are developed for conducting health study. Do you feel that that is appropriate for us to do? I mean, does that not kind of almost start making too fine strokes for the way that Rule 12 looks? Or can you give me some background on that?
When we were putting this together, to an extent, I viewed this as consistent with the mitigation project, in the sense that the problem has been that people can't file claims for a mitigation because they can't prove that what they're suffering from is caused by geothermal. And so in order to be able to compensate people for specific claims, you need to have some kind of basis for paying a claim out. And I felt that given what's been coming from the community, that this was an appropriate fund to pay for such a study, because it becomes the basis for which you can determine whether people have been impacted and whether their claims for compensation are legitimate. I thought there were some issues with the claims adjuster per se, because I think when we started off down this road and these rules were originally adopted, we thought people were going to come in, they're going to present a claim, the claims adjuster evaluates whether the size of the claim is appropriate, do they have their receipts for their doctor's visits, do they have their receipt if they had to evacuate and stay at a hotel. The reality has been that there have been virtually no claims made under this for years. And the difficulty has been that people can't make a causal link people are convinced that in fact their health concerns are directly related to PGD, but they don't have the studies to support that. So it's been a tremendous issue, I think, in the community, and it's also been to a certain extent divisive in the community because there are some people who don't believe that people's health complaints are created by PGD. We looked at, for me, there was also some practical realities, and I don't know if people are discussing this, but the other fund, what was originally called the Royalty and Relocation Fund, and then became the Community Benefits Fund, and then now it's been changed back, I guess, to that. The primary purpose of that fund is really relocation, and I have so many current claims in the office that the money in that fund will not be available to pay for a health study for several years. And that's because we currently have about 2.1 million, and based on the number of applications that I have for relocation. And because the relocation fund doesn't say that you have to prove that you've been impacted, it just says that you have to have a desire to be relocated. And then there's a preference under our rules for those properties purchased or permitted prior to 1989, and there's a preference for people within 1 mile. Well, all of the requests that I have, without exception, are within 1 mile of PGD. None of them is pre-1989, and since the rules just have a preference for pre-1989, the ones that are coming in qualify for that preference of being within 1 mile. But we calculated them out at 130%. And basically, based on 130% of value at the time people applied, we estimated that the purchase price would be in the neighborhood of about $4.8 million. There's currently about 2.1 million available in the fund. Revenues come in at the rate of about $700,000 a year. So you do the math and you can see that it's several years out before we have anything available. That's assuming that there's no more additional things filed with us for relocation. So that if you want to fund a health study, this really is the only source that's available today. And yet it addresses, I think, what a lot of people in the community are saying, both pro and anti-geothermal, is that site-specific, that some kind of health study that you could look at, and that there's community buy-in. So the question is, was this appropriate? I thought this was an appropriate fund. And the process, though, is an issue because I don't know the claims adjuster. And we didn't really define what claims adjuster is either. And part of it is because when you draft rules, you aren't necessarily anticipating all the different nuances of proposals that come before you. So that's one of the things that may or may not need to be adjusted. You may need to look at whether you need a definition of a claims adjuster. You may need to look at whether this is something that is not necessarily a claims adjuster, but something that the commission itself makes a determination on it. And just like when we went through the RFP on waste to energy, we went to the county council, and at a public hearing, the county council voted on whether they would approve that contract or not. And it gave people an opportunity to come forward and say whether they supported that contract being awarded. And so that may be the process that you want. But I think at this point, we really need to examine the process more than anything else. And raising the questions about what can or cannot be done and what the process ought to be is probably where we're at right now.
Yeah, my hope is that at the end of, not today, but very soon here, that we have that clear process and all the questions are answered. That's why I write down the questions and let's bring those out so we can get clarification on those from procurement, who claims adjuster, identifying what that actually looks like. Anything else that we really need to look at. And so what I'd like to do is actually see if we can go into an executive session, get a little bit of legal opinion, and then maybe walk our way through that process. There's a plan. We can answer questions. You know what I mean? Can we get a motion to move to executive session?
Mr. Chair,
Commissioner Allen?
I move to go into executive session.
Second.
I was just gonna say, I think Ms. Victoria Glidewell advised that you need to state why you wanna go into executive session.
Yeah, from what I hear, you want to go into executive session, consult legal counsel, get some legal advice regarding some of the issues and potential liabilities regarding this item.
Exactly.
Yes, I move to get legal advice.
And there's a second on that for the legal advice. All those in favor, aye? Aye. Opposed, none. Okay, we're gonna go into executive session. Everybody's gotta leave the room for a minute, and then we'll call you back in. It shouldn't take very long. Thank you.